Estate planning attorney, estate planning lawyer, estate attorney. Skilled estate planning attorneys in New York. You've worked hard all your life to accumulate the estate and wealth. And regardless of the extent of your assets, you have the right to decide who they go to after you are gone. Many individuals put off developing a comprehensive estate plan for someday. However, when the unforeseen happens, those individuals may no longer have a say over who inherits their estate or in what proportion. We know that these are difficult conversations to have, but sometimes the most difficult conversations are the most necessary. The skilled estate planning attorneys at Sishodia PLLC can guide you in learning how you can care for your estate while you are alive and provide for your loved ones when you are no longer here. Estate planning is much more than drafting a will. An estate plan can also include how your medical care is handled should you become gravely ill or incapacitated. It can ensure that your children are appropriately taken care of. It can reduce the tax burden on your loved ones after your death. It is never too early to start thinking about estate planning, or the legacy you wish to leave behind for your loved ones. With our New York City estate planning lawyers helping you understand your options, you can be prepared for the future, whatever that may hold. Why everyone needs estate planning. Estate planning is the entirety of many different efforts and documents with the primary goal of setting up your estate for the future. No matter how extensive or limited your wealth may be, estate planning should be an extension of any financial planning you do. While financial planning looks toward creating wealth, estate planning helps you preserve it for yourself and those you love. What your NYC estate planning attorney can do for you. Having the guidance of a skilled estate planning attorney can help you make the right decisions for the disposition of the assets in your estate, saving assets from taxes and creditors, the management and protection of your assets while you are alive, planning for your long-term care, establishing who will make healthcare and financial decisions in case of an emergency, establishing who will be a guardian for your minor children, providing care for dependents. Some important estate planning devices we can help you create include: a will set out exactly how your estate will be allocated after your death. Trusts that can offer unique protection for your estate. A durable financial power of attorney naming a person to make important financial decisions if you become incapacitated. A healthcare proxy naming an individual to make critical healthcare decisions should you become unable to do it for yourself. A living will expressing your wishes under certain medical situations. Creating and drafting any number of other devices to protect your wealth and properties in particular cases and financial situations. Who should have a will? A will is one of the most important foundational estate planning documents. It is a set of concise instructions that designates your executor, how your properties will be distributed, and names a guardian to your minor children. Without a will, you don't make these decisions. The state does. Dying without the benefit of a will means that you die intestate. In that case, state laws decide how your property will be distributed after your death. Intestate succession is a single set of rules that determines what relationship gets what percentage of your wealth or estate after your death. While it was developed to mimic how most people would choose to leave their properties, it is not suitable for many people, including those who are unmarried or are involved in other non-traditional families. At the very least, intestate succession is probably not exactly what you would have chosen for yourself. Trusts and how they are used in estate planning. Trusts are often used for the management and protection of wealth and properties in specific situations. This is an estate planning device that holds assets separately from you, the grantor, for the benefit of your beneficiaries, and is managed by a trustee. There are many different types of trusts for many different purposes, but two types are most common for purposes of estate planning. Testamentary trusts. Testamentary trusts are established as part of the will and only go into effect upon your death. This is also an estate planning tool that has specific goals, such as providing a spouse future income, preventing children from inheriting before they are able to responsibly manage a great deal of money, ensuring that special needs beneficiaries will be taken care of, or other specific requirements. A trustee manages these properties that are passed through your will for the benefit of your beneficiaries. Revocable living trusts. Unlike the testamentary trusts, revocable living trusts go into effect immediately.